Welcome to the Melinda Eitzen Show. I'm Melinda. Today we have with us fabulous attorney, Philip Moore. Welcome, Philip.
Thanks for having me.
Thank you so much for being here. So today we're going to talk about the exciting topic of summary judgments.
Yeah, I guess it's kind of exciting. It's just something that's not used very much in family law practice, and I've always kind of thought that it should be, as a way to kind of narrow issues that may ultimately go to trial, and if you're lucky, how to not even have to go to trial, get the case disposed of quick.
I agree. I think it's very underutilized. I first started doing them because I heard Judge Oldner, when he was still on the bench, at a seminar say, "You family lawyers are underutilizing this." I was like, oh, okay. If a judge says that, maybe I should pay attention. So I started doing them. But for the listener that is not a lawyer, explain basically high level, what is a summary judgment?
Well, summary judgment's like a procedural mechanism whereby either the facts as we understand them are undisputed, and we're simply arguing about whether those facts rise to a genuine issue of material fact. In the absence of a genuine issue of material fact, the judge can just take all of the evidence and just rule summarily, hence summary judgment, and render a decision outside of the finder of fact. Now, obviously in bench trials, that's the judge, but sometimes there are juries, and we all know how expensive and difficult and time-consuming jury trials are. And so summary judgment motions are a way to get a case done early if the law and the facts are on your side.
And that could be in a divorce action, or it could be post-divorce in what we call a modification.
Correct. You know, in the context of just a divorce, there's all kinds of things that you can do. Like people will argue about whether something's a gift, which would be separate property, or, you know, if assets are commingled and things of that nature. Is it community or separate? Or what percentage of it is separate or community? All sorts of things that get into that whole context. But yes, you know, outside of the, you know, the divorce, the original round, a lot of times you get into the modifications, and that is really an area where I'm talking about modifications of custody orders. That's really where I think summary judgments are pretty useful. A lot of people just think, you know, modifications is always just about the amorphous best interest of the child standard, and it's not. Mm-hmm. There are benchmarks that the courts have set that this qualifies or this doesn't, and people don't take an opportunity to flesh that out.
Okay, that's great. And I think one reason it is underutilized is family law is so fact-specific. Correct. And fact-driven in every case. It's not one fact. It's usually many, many bricks in the house. And that could lend itself to not be summary judgment friendly, right? Because if the court can't just read the physical evidence and say, oh, even if all that is true, then XYZ, then summary judgment doesn't really work. So I think that's why our community has underutilized it. But you brought up there's more than best interest on modification. There's a threshold of material and substantial change. And that's where you've been successful using this summary judgment tool to get rid of the case early.
Correct. You know, and just a lot of the people just don't realize is courts really don't like do-overs, right?
Yeah.
So the court's going to look at what were the circumstances that existed at the time of the order that the judge entered previously, whether it be the divorce decree or the original order from a suit affecting parent-child relationship. And so we have to look at what things have happened since. Mm-hmm. And you have to look at, you know, whether that's material, which is kind of in my eyes always is like the subject matter of it, and then substantial being the degree of it. You can have a material change, but maybe it's not substantial enough to justify a modification. And the courts have just ruled on several kind of things that are like, look, you know, these are just things that we all understood could happen. If it was anticipated, in tort law, personal injury, they would say foreseeable. If it was anticipated or foreseeable at the time the underlying order was entered, then it's not going to be a material and substantial change.
Right. So what's exciting about this is you can look back at what happened before. Like you said, the courts don't want to do a do-over, meaning you ended up with this order, the original order, divorce decree in some cases, suit affecting parent-child relationship, another order, either because they agreed, right? Everybody agreed and we entered an agreed order, or because they already had a trial and the judge ruled. They don't want somebody to say, oh, 5 months later, I changed my mind. I want to modify, or I want to modify the parts that I didn't win at the trial. The judge is like, we already did that. We just did that. But they want to allow, because it's children and the lives of children, if something dramatic has happened, for a way to make a change. So let's give a really dramatic example.
Oh, goodness. A change that would justify a modification?
Yes.
Well, you could start having a child that, may have been behaviorally or intellectually challenged. We've always kind of known that, but there's been some progress made on the one hand, or kind of a spiraling effect. And so we always kind of knew that we were going to have trouble with our kids. And I mean, we all do, right?
Yes.
But, there could be things, a diagnosis of autism, right? And then we have to start getting into programs where they do ARD counseling, and you see all this ABA testing and ABA therapy that has to get done. And the kid's schedule has to change. Accommodations have to start being made. And maybe the back and forth of exchanging possession of the kid is becoming a problem because of all these additional changes. And so, the courts in those kind of circumstances are going to find that a material and substantial change in circumstances, has occurred.
So that's very child-focused example.
Correct.
Another example could be someone got arrested because they're dealing drugs out of the house.
Right.
Right. Somebody is medically, like the adult has a medical problem that makes them not able to care for the child. Or, something dramatically horrible happened that nobody knew was happening. The child's sexually abused by a parent.
Correct.
That parent, obviously, the court needed to have an avenue for us to come back in and say, whoa, judge, something happened. We've got to get that for safety of the child. We have to get the child away. So that's why there's the ability to do a modification, right?
Yes.
But is it, oh, well, I just don't really like the schedule that I agreed to.
No.
I regret it. I would like to modify.
And we can get into that, a little bit about like what are some things that courts, just really don't want to have clog their docket, right?
Right.
And going back to your point about judges like, Judge Oldner, who I've been told the same thing by, you give them an opportunity to get something off their docket that's on its face kind of ridiculous. You should be really considering a motion for summary judgment, like certain things that courts find not to be a material substantial change in circumstances. We talk about things that were anticipated, a kid simply getting older or, in advancing in school is not something that's such a big deal.
Mm-hmm.
We all know the kid's going to go from third grade to fourth grade. We all know that we know that all after elementary school comes middle school, and then after middle school comes high school. And, as the kid gets a little bit older and their routines change in a significant way, they might be having to take classes at a community college because they've advanced out of the high school programs, or they might have to start going into a remedial school where they have to get to a different campus. And so the back and forth changes, stuff like that, can be kind of problematic and something for the court to address. Certainly as kids get older, they get a little bit more independence. And, we certainly don't like to put the cart before the horse with kids, right?
Mm-hmm.
But when they get a little bit older, they have a little bit more autonomy. They still are subject to a decree or an order, but some things have to get revisited. But, again, simply, starting school or getting older is not going to cut it.
It could be decision-making power, right?
Right.
I had a case where they were supposed to make educational decisions together, subject to agreement. That's what their agreed decree said. But they couldn't agree if they should hold back this child from first grade or put the child into first grade. We had to have a trial. Judge Roach had to decide if the child was going to be held back or not, truly. So he did allow the modification. We won. We wanted the hold back, and the child was held back. But that's, kind of ridiculous that a third party would have to make those decisions instead of the parents. But that could be an example of no one filed a motion for summary judgment and said this isn't a material and substantial change, but there might have been an opportunity there.
Correct. Another one, I've been on the losing side of some summary judgments too, and I'll just win them. I had a case earlier on in my career where there was a geographic restriction of the entire state of Texas, but the parents were exercising a 50-50 schedule.
Oh, gosh.
And dad had the right to establish the primary residence, and he moved to Austin.
Oh my gosh.
And so I was like, well, darn it. I think that's going to be a material substantial change in circumstances, and my client can't exercise the possession.
Right.
Not so fast. The court said, yeah, you can. You just have to move to Austin to go do it.
Oh my goodness. Well, I don't necessarily agree with what the court said in that case.
Well, Judge Gabriel granted that motion for summary judgment out in Denton County, and that's really, Melinda, where I started getting focused on summary judgments and taking that application of them into the family law practice. Now, I'd done a lot of them in my civil career before, but that's what really got that started. And I want to say that was probably 2011.
What do you think makes people hesitate to do them?
I think a lack of familiarity.
Mm-hmm.
I think there are a certain number of family law attorneys, who just kind of get into family law because they just think it's easy, and they don't pay attention to the Texas Rules of Civil Procedure, the Texas Rules of Evidence the way that they should. Certainly your firm's not like that. You guys are really good about that stuff.
Thank
But
you.
there are just people who, exit, civil litigation practice, or just they're young and they hang a shingle and they just go in and just think it's preparing a little bit for a hearing. Mm-hmm. And they just don't really pay much attention to it. They don't do the advanced family law. They don't do their seminars. They don't work on getting board certified or wherever else. And so they're not really abreast of case law. And they just kind of take things for granted.
Yeah. I think part of it is cost. And if I'm counseling a client and I see an opportunity to one, I tell them the only reason not to do this is cost, because it's such an advantage besides possible success. I tell them you're probably not going to win on a motion for summary judgment because of the fact, if the court finds, gosh, I really need to hear evidence, live testimony, all that to sort out these facts because I can't tell. It's such a he said, she said. We have forced them by doing this to show me all of their cards early. And
Right.
I think that is very helpful for trial preparation.
I definitely agree. And that's probably a good segue into the different types of motions for summary judgment.
Yes.
I had previously been discussing more along the lines of a traditional motion where you file the motion, which you can file a traditional motion at any time after you appear or answer if the facts are clear. You attach affidavits, certified copies of public records that are properly authenticated. You might have a deposition excerpt from some deposition where there's admissions by the other side. Pretty straightforward. Now, the no evidence motions are a little bit more fun. I want to say they came out, was it 2006, maybe? Can't remember when 166 AI rules was implemented, but
I do not know that.
this one, the no evidence motions are really fun, like you said, because, you might, serve discovery and you'll, ask, to identify what the material substantial changes in circumstances are. Those answers might give rise to a traditional motion where you say, well, this isn't enough. This doesn't cut it. Otherwise, after the court or the parties have had a reasonable opportunity to conduct discovery, whether they have or not, if the case has been pending enough time, there's been an opportunity to do discovery and someone's just sat on their hands, you can file a no evidence motion for summary judgment. And so, you file that 21 days out in advance of a hearing or a submission date. They have their responses due 7 days before the hearing or submission date, and you can kind of force them to marshal their evidence, like you said.
Yes, I love that.
And then they have to show you exactly what it is they're saying. And so then they've done that, and you get back, if you do a reply, the last word, as they say, right? And I love
the last word.
so much fun. But when you're in the situation of doing a reply, you kind of get back into the traditional motion for summary judgment part where you say, all right, they finally come forward, they produce what they say they have, and here's why it doesn't cut it. Mm-hmm. And so you get into those cases or the topics that we were talking about earlier on in our conversation here, and then you just leave it up to the judge.
Yes. Well, and let's say you talked about a lot of people kind of jump to the best interest. They're not even thinking about this threshold. And at trial, they're not even talking about it. They're just allowing the other side to make a best interest argument. Well, what's nice about the summary judgment practice is you have really made that issue known to the court. So even if you don't win at summary judgment, you're getting another bite at the apple in a way to make your argument about they do not meet the threshold standard. We don't even need to be talking about best interest because they can't get there. And now the judge is going to hear that twice because they're going to hear it in the form of the summary judgment and then they're going to hear it again at trial.
Absolutely. And I recently filed a motion for summary judgment out in Denton County, and we had a hearing on it. I prevailed on the majority of it, but I also was able to determine what wasn't going to be necessarily the best arguments at trial. And Judge Shanklin, kind of delineated, what we needed to do. And so it dramatically reduced the amount of time that I had to actually spend at trial in preparing for trial.
Oh, yes, because sometimes when we're preparing for trial, we're thinking, well, if the judge feels like it is a material and substantial change on this, then I have to go down this path. Okay, that path, this path. So you've narrowed by your example, because same judge, you're getting a lot of good input to help you prepare better. So that's why I say cost is the only reason not to do it. If the client says, hey, I can't afford all of that on top of trial, okay, well, that's a reason not to do it. You don't have to do it. But if they can afford it, it really could increase their chance of a good result at trial, even if we were not successful at the summary judgment phase. You talked a little bit about there are cases out there that we can look to where they talk about a specific example, like the one you gave of just aging is not necessarily a material and substantial change. What's some other examples like that?
Like, a parent's remarriage, right? I mean, that's just something that we kind of understand is going to be a possibility. And so, that by itself isn't really going to get you there. Something that can get you there and also can't get you there are changes like in the kid's extracurricular activities. The simple fact that the kid has started playing rec soccer.
That's probably not
Right.
enough.
Or on the other hand, you have this really, really gifted athlete who's been playing at the upper levels of club soccer for, the FC Dallas club or whatever else. And this kid is good enough to probably go play in Europe,
Yeah.
And so those schedules get extremely demanding. The kids have to travel. They might need a private tutor. They might be homeschooling at that point.
Mm-hmm.
So it is fact intensive, but simply just getting your foot through the door on there being some change or some different need isn't going to get you there. And so the cases we'll talk about, what are slight changes in conditions. And so the court is going to have to kind of like, look, yeah, it's on the scale. I can see a 0.1 gram there, but you're not moving the scale enough for this to matter. And this is not going to be a trial issue.
You have to connect the dot between the change and how it's affecting the child and why you need the change, the modification you're asking for to alleviate that. It's not just a list of, well, they got married, they moved, da-da-da-da-da-da. The child's 3 years older. If none of those facts have anything to do with what's going on with the child, that it's the schedule doesn't work now because of that and the change you're looking for, it all has to connect. Right.
Always looking for that nexus, right? You might have a change in circumstances because, it is a material change that you've changed jobs, right? Is it going to be substantial if the job change really doesn't affect your schedule or your ability to have time or access to the kid?
No.
And so, if you're say I've changed my job and I'm still working 9 to 5, but because of that, I want more child support or I want to have every spring break. I mean, that there has to be a relationship between the change and what you've asked for, like you said.
Mm-hmm. Now, one thing that's interesting about all of this is when the court is considering this, you're going to be making the argument about foreseeability. Some of it's obvious. It's foreseeable. They're going to age, right?
Right.
But sometimes it's not obvious. And so in your final orders, I think it's important to have either findings or just statements or intentions like, we all know, and it has been discussed, that husband's probably going to move to Houston in a year.
Right.
So that's in the record now. You don't have to later argue, no, we knew that. We knew that was foreseeable. You've put it in your order. And that wouldn't necessarily be obviously something you would put in an order. But when you're thinking ahead to, hey, the modification, I want that to be seen as foreseeable. I don't want them to say, oh, wait, you moved to Houston, that now we have to change everything.
Right. The Texas legislature has done a lot in recent years to kind of just prevent that.
Mm-hmm.
So we have these possession orders for, more than 100 miles, up to 100 miles, or up to 50 miles. And so depending on where the parent moves, the possession schedule is kind of laid out.
Mm-hmm.
And you could also have it to where, there's just a standard possession order, but, you contemplate in the order, hey, we know that dad might move. And if he does move within X number of miles, there might be an agreement or the court's ruling that the dad might start having 50-50 possession once the distance gap is closed. And so that is a big thing about drafting, but you'll have to make sure you always look at what your order says. And from that vantage point of that order, with the relief that you're requesting, make sure your client understands and has some insight into what's coming next.
Mm-hmm.
Because, a lot of times in family law cases, it's the long game, right? You might have a short-term loss, but you've got some things that you're trying to do down the road. And you want to make sure that you're not shutting yourself out. You might wind up facing a motion for summary judgment because you're requesting relief from the court that was foreseeable.
Right. So it's hard to always have the crystal ball and know, do I want that statement in or not?
Right.
But it's important to know. So you mentioned that this could be heard by submission or by hearing. Explain what that means.
Well, right. I mean, in the appellate world, we have, big records, reporter's record, clerk's record, and everything's just there. And you write a brief and you do your arguments in front of this panel of judges. And that's, typically how, intellectual legal arguments are made, right? And in the context of a trial court, you just got one judge.
Mm-hmm.
Some judges a lot of judges really want the summary judgments by submission.
I agree. That's been my experience.
Because if you think about it, and
submission means you're not there in person.
Correct.
You're just giving it all on paper.
Right. So you file your motion, they'll file a response. And then if you want to, you can do a reply before the submission date. And the judge just reads everything, which, I really think by and large is mostly appropriate because the judges really can't consider anything that's not part of the summary judgment evidence. Now, there could be reasons why submission is not appropriate. You might make some objections to their summary judgment evidence. The other side might have offered up a sham affidavit to try to defeat summary judgment.
Explain that, a sham affidavit.
Well, sham affidavits are funny because, you might have a deposition, right, where you've got them on the hook, right? And then they attach an affidavit where they kind of change your story. And so if you do that in some meaningful way, changing your story, but you don't do it with a sufficient enough explanation, then the court can disregard that affidavit. And so sometimes you're getting into special exceptions or objections to summary judgment evidence, and it's up to the judge if they want to do submission or not. I certainly know my recent experience with Judge Shanklin. He prefers it. But if someone asks for a hearing, he's going to give you one.
And sometimes it's nice if you feel like the judge isn't a reading judge. I hate to say it that way, but some judges like to read all the material ahead, and some judges they just don't. They just rather you tell them what they're looking for before they read, So they might come in cold, and then you can say, hey, judge, this is the deal. And then when they read it, they're more focused on what they're looking for. You talked about objections to the evidence. So you mentioned that one reason maybe people don't do a lot of this practice is they're just not that type of lawyer. They're not familiar. They're not rule focused. And that applies in a lot of areas of litigation. But there are objections you can make to the evidence they attach.
Correct.
Right? And that gets really technical.
Well, right. You gotta have a properly authenticated document. Just attaching some, record of a visit with a child's pediatrician isn't going to cut it. You have to be able to prove that it was kept and maintained in the ordinary course of the pediatrician's practice, all these other things. And so you will need a business records affidavit for that. They might attach a police report that can be problematic for a couple of reasons. One of those is, was it certified? Is it a certified copy? And then two, there's still hearsay statements in there. Okay. So if it's a witness and the witness is not a party opponent, just some third party, if you're trying to get into the court's record, the testimony of a police officer from a report that he, with information that he got from a third party to the suit, you're going to object on the grounds of hearsay. And so, you go through all of that, and then that kind of whittles down, perhaps particularly in regards to the no evidence motions when they produce the evidence, trying to show they've got evidence of something. That's a way to strike out or knock out what they're trying to base their case on.
And one reason for the rules of evidence is the legislature has thought a lot, and the Supreme Court, about how can we make sure what the court is relying upon is reliable as possible. That's
Right.
the reason for these rules, is they've identified, hey, it's more likely to be suspect if blah, blah, blah. Now with AI, everything is more likely to be suspect.
Right.
So that's the point why we have these rules. And we can use them as a tool to help the evidence be as reliable as possible to the judge.
Correct. And I think that's another good point that you made there, Melinda, is when prospective clients are looking for attorneys, you need to make sure that the attorneys, just not likable and smiley. You want to make sure that they have some tactical grit and that they're really abreast of the rules of evidence and procedure. And I struggle with my evidence a lot. I have to go back and look at things and make sure that I'm freshed up on it or that I'm looking at it in the right way. So even though I'm abreast of them and I feel competent with evidence and the procedural rules, you still have to make sure that you're always reading them. And when you're getting into the weeds on these summary judgment motions and the different ways to object to evidence and things like that, that really makes you go back and look. And this kind of goes back to what I was saying earlier about folks that run out and hire attorneys that just think that family law is some kind of easy breezy thing. Let's just show up for a hearing and argue about best interests and all other stuff like that. It's going to be really advantageous for a consumer looking to hire an attorney to find out, the capabilities and credentials of those that they're hiring.
I like what you said about refresh yourself in the evidence. We've both done this a long time, and I always, before trial, I think about each piece of evidence I'm trying to get in and all the arguments I'm going to make to get it in, even not just the best argument. Like I think, it should come in under this rule. But I have learned that I don't always think like the judge.
I know.
And sometimes the reason I think it should come in is different than the reason the judge thinks it should come in. So when I'm training young lawyers, I'm like, you need to have three arguments of why this piece of evidence comes in. And then every piece of evidence you think they're going to get in that you don't want to come in, you need to have three objections, because the one that just seems obvious to you may not be how the judge thinks about it. And, when you do this long enough, you have a judge go, well, overruled on that objection. They have one in mind.
Right.
So you cannot think, I've got the one, that's it, because it's all happened so fast in trial. We have to be ready. Now, what's nice about a summary judgment, it's not happening as fast, right? We get to prepare it on paper. What's the process timeline of the summary judgment?
Well, whether it's traditional or whether it's a no evidence motion, the hearing dates are the same. You got to give 21 days notice, right? So, you file the motion on a Monday, you start counting on Tuesday, and the court can't have the hearing before day 21. And then you go backwards 7 days from that hearing, and that's the deadline for them to file the response. Now, replies, there's no real express provision for them in the rules of civil procedure, but a reply, your last word, could be filed at any time before the hearing. You need to check local rules to see.
I usually think 3 days, but maybe that's just reasonable.
I think that's kind of a custom, but it depends on the local rules. You have to make sure you always look at those. And
my gosh.
They're changing so much differently now between Colwyn and Dallas and Denton.
I was just telling one of our young lawyers, before you do anything that anyone's asked you to do, read the local rules, because you're reading it now as to that assignment. They have local rules about how do you present a TRO, read the local rules.
Yeah, but with the no evidence motions, again, you can't just file them right out the gate like you can with the traditional. So on the no evidence stuff, if you're going to be the movant, it's probably smart for you to have served discovery requests and have gotten a response before you try to file the no evidence, because the response might be there hasn't been enough time to conduct discovery, depositions haven't been taken, all this other stuff. But say, for example, you're the respondent and the petitioner filed the suit and hasn't served anything. The case has been on the docket for 7 months. You file your motion.
Yeah. We've talked a lot about summary judgment motion on the modification front,
Right.
but it's available in other areas. Good example I can think of in a divorce case is every once in a while you'll have an estate where one person says, you know what, like 99% of the estate is my separate property.
Right.
Because of X, Y, and Z. Well, that's a huge claim. Assuming it's a decent sized estate, that means they get most of the enchilada. And that should be known. I would want to know that before trial.
Absolutely.
And that really is a good example of how it could be utilized. It's almost severing out a piece of the trial, but utilized in original trial level to simplify things at trial. So you're not thinking, well, wait, if they're affirmed on that, my strategy is different at trial than if they're not. And it's probably, if it's that dramatic, it's probably not one asset, right? So there's going to be all kinds of tracing on a bunch of different assets.
Right.
That's going to take a lot of time, and not all of our courts give us as much time as we ever think we need for trial. So you can also gain the advantage of not having to use all your trial time.
Exactly. That's very important. We all familiar with how temporary orders hearings work, the very limited amount of time that you get. But if you're in a final trial, you're a trial before the court, we call them TBCs.
Mm-hmm.
You might get 2.5 hours aside.
Very common time frame.
And so the whole tracing stuff, because we all know that if it exists on the date of divorce, it's community property unless you rebut the presumption with clear and convincing evidence. And that could be really time consuming at a trial, man. You're going to have an expert there with the bona fides and who's done all the work to dot the I's and cross the T's and connect the dots. And that just takes so much time. And you've got other big issues. And you can have the little esoteric thing, hashed out with an expert report and an affidavit, and showing all the supporting documents and just knock that out, like you said. I mean, it's a time management thing.
Mm-hmm. So I recommend utilizing it in all areas of family law.
Right.
Think of where you can use a summary judgment. If you're a lawyer listening, that's your new charge. Philip, tell us, where is your practice? What areas do you work in?
I practice in Frisco, Texas. I'm Collin, Dallas, Denton. Mainly, I get out to Grayson County. I'll go out to Hunt County, but I've tried cases across the state. In Corpus Christi, I've been out in Kerr County. I've been out in Williamson County. I've been over in in just Bear County. I've had cases out there.
Help.
It just sometimes there are areas where in small communities, everyone knows who they are,
Mm-hmm.
and so there's kind of a conflicted out kind of thing.
Mm-hmm.
Or all I do is family law,
Mm-hmm.
and so there are a lot of attorneys out in these smaller communities who are jacks of all trades and masters of none. And so I've actually been brought in on cases to do summary judgments.
Oh, that's fun. So when you say family law, you mean divorce, modifications, suit affecting parent-child relationship, meaning they were never married, but you do not mean estate planning.
No, absolutely not.
I think that a lot of people are confused. That sounds like it would be under family law, right?
Oh, goodness.
But it is not. Well, thank you so much for being here. We're going to put your contact information on the screen so people can find you. And I highly recommend Philip. As you can see, he knows what he's doing. So you would be wise to hire him for all of your family law needs. Thanks so much for listening. And please tune in again next time to the Melinda Eitzen Show.